Hi, and welcome to this week's episode of Ask Amy. Our guest today is David Kahne. He has been representing homeowners in battles against their HOAs for going on 20 years, and you've been my expert anytime somebody emails me and has a question about their HOA. Thanks so much for joining us today.
It's so good to be with you again.
Yeah, I know you stay very busy because you also do a lot of work with the Texas HOA Reform Coalition, trying to improve laws and change laws in the state that impact all homeowners with HOAs.
Right.
So we want to get into, we're not going to let you leave before you talk about some of the things that you guys are working on for the next legislative session. But first I said, hey, can you help me answer some of the questions that people are asking us? So we're going to get right into that.
Great.
The first one comes from Brenda, and she wants to know if the state of Texas and the Texas Property Code prohibits term limits for HOA directors. Apparently she's having a problem with this in her subdivision.
So the short answer is no. You can have term limits in your typically they're in the bylaws for your subdivision, and I think term limits are a great idea. If you want to find out whether you have term limits, you're going to need to look at the restrictions for your subdivision. Now, the restrictions or the bylaws are supposed to be readily available to homeowners. Mm-hmm. Sometimes they are. And in those subdivisions, I don't hear from people. But if they're not readily available, what do? You go to the county registry of deeds. And if it's too difficult to navigate that, and it can be difficult to navigate that, then you can go to the Texas Real Estate Commission, where at least all the subdivisions are supposed to list all of their governing documents and where to find them.
And that website we will put up for people in our show notes because that is very helpful. It lets you go onto the Texas Real Estate Commission website, search for your subdivision, and then it just sort of guides you there. It makes it a little easier to find these documents.
Right. And okay. It helps your realtor if your realtor's less experienced. The experienced realtors, they all know how to do this. But if you might have a new realtor, this will help them. Okay,
and then also you said, well, there aren't term limits. There are some other things that are not as vague or specific to each. There are some things that there are some limits when it comes to directors.
Yeah, there are not very many limits, but there are protections so that if a person has been convicted of a serious felony, for example, in the past 20 years, they are forbidden to be on the board. One of the more recent changes is we don't allow for husband and wife. If two people live in the same house, they can't both be on the board at the same time. And the final one that is generally allowed, there's a few limits on it, but a subdivision can require that you live in the subdivision.
Mm-hmm. Sounds like common sense, but maybe not.
Well, we also protect the right of landlords. So some people are investors and they buy property in a subdivision. So not all of the board seats can be limited to residents, but some can. The one thing that your subdivision cannot do is they cannot prevent you from running for office. They cannot prevent you from voting if they claim you owe money. And that was a huge advance for subdivisions. We don't have that rule for condominiums, and it's really a big weakness in the law. Mm-hmm. There are frequently problems with directors that want to keep in power, and they impose a lot of charges on people. And that, of course, gets the people very angry, and then the people find out that they can't vote, and that makes them even more angry. So that's one of the things we want to change this year. We've tried for several years. I think we'll have some success this year.
As it relates to condominium associations, not homeowners.
Correct. Generally speaking, if you're in a subdivision, you're more likely to have protections than if you are in a condominium, and we would like to expand the protections so that many of the things that homeowners in subdivisions have, condominium owners also have.
Yeah, okay, our next question comes from Rita, and she wants to know if there are any restrictions on how much an HOA can increase dues from one year to the next.
So the short answer to that is it depends. In general, the answer is no. There's no statutory limit, and the reason is there may be an unusual expense that comes up in the homeowners association. If they need to fix the pool, fix the clubhouse, there may be additional costs that they need to pay, and the only people to pay that are the homeowners. But your governing documents, again, same set of governing documents that you would find in the county records, may impose limits. In fact, my very first homeowner association case involved a situation where the subdivision had a limit that said no more than either 10% or the cost of living increase in any given year. And your subdivision may have that. And so you need to, if you're concerned about the increase in assessments, then you need to look there. Now, I'll tell you, I've also run into situations where lawyers for the subdivisions have engaged in creative thinking on how to get around those rules. But in general, you can have rights, and it's reasonably common to have some limits in the governing documents.
Yeah, you know, with a lot of these questions that people are asking us, and I know you hear them too, they're like, well, I don't, you know, I'm fighting this or I'm fighting that. They often say, I don't have extra money to go hire an attorney. You said one of the best defenses or best, I guess, thing that homeowners can do is join up with other homeowners. I
do say that. The problem is that if you're by yourself, you run into several problems. First, lawsuits are expensive. But second, you might be retaliated against. And so I very typically will recommend to homeowners that before they think about a lawsuit, think about getting together a group of people who share your views, or at least you have some overlap, so they may want something and you may want something, and how can you work together? And that has several good effects. The first is you're more likely to win. You're more likely to at least be able to get some people elected to the board. If you have to go to court, then a judge is much more likely to care about it if it's 25 or 50 people who say this is a problem than even if it's just Amy.
Yeah, just one person.
The judges have a lot on their plate, and to get their attention, having a big group helps a lot. So, and of course, it's much harder for a board to retaliate against 25 or 50 people than it is to retaliate against just you.
Yeah, you just don't think you're going it alone. And on that note, somebody else asked, hey, is it true that you can go to small claims court or a JP court? You don't have to hire an attorney and go to civil. You could take on some of these issues yourself?
So the short answer is yes. You can go to justice court, what they now call it, but it is what I think of as JP court. A lot of people still call it that, the justices of the peace. And there was a relatively recent statute 2 sessions ago that stated that homeowners can go to JP court. The problem is the JP courts can't do very much. You can, basically they exist to sue for money. So if the homeowners association owes you money, you can sue them. But they typically do not have authority to order the association to do something. There's one very important exception to that, and that is if you want to get documents from your homeowners association. Well, most of the documents should be made available on your website, on the association's website. But again, let's just say in the bad associations, the one I hear about, the ones who write to you, sometimes they hide some of those documents. And if the association refuses to give you documents, I mean, they're your documents.
Right.
It's your association. The documents belong to the owners with a very limited set of exceptions that make sense, mostly that if Amy and I live in the same subdivision, I shouldn't be able to see your dirty laundry. So if there is a problem that you've had with the homeowner association, your information is private. But financial information, information about lawsuits, information about rules, all of that belongs to the owners and by statute must be made available.
So I'm going to cut you off there, and I want to talk about a little bit more about that when we come back, because you're big on documents and transparency and openness.
Yes.
So we're going to talk about where people should be able to find those, how they should be able to get them, and something that you guys are working on for this next legislative session.
Great.
All right, we're going to be right back. Welcome back to this episode of Ask Amy. We are talking about homeowners associations, and this is a hot topic no matter the time of year, no matter what's going on. We always get emails and questions about HOAs. I usually always call David Kahne because you can get the answer for me about is this legal or can they do that. We were just talking about documents, and I think a lot of people, their questions can be found in documents that they don't have readily available in front of them or they don't know where to find. Can we talk first about documents that a homeowner is entitled to, you should be able to easily get? These are things that basically you have a right to.
Yeah, so you have the right to learn your rules. It's really discouraging when there are some homeowner associations that don't put their rules and regulations out for everybody to see. Hidden rules are obviously bad. But that's mostly been resolved now. I don't get a lot of calls about that. What I get a tremendous number of calls about is financial information. whether we're talking about budgets, whether we're talking about contracts, whether we're talking about how much is being paid to the management company, for example, all of that information you as the owner have the absolute right to get. In addition, the only place, I should go back for a second, the only place where homeowner associations sometimes have hidden the rules are on fines. Now, I tend to think there's a big problem with homeowner associations imposing fines. Most of the time, we only allow governments to impose fines for good reasons that I can get into. But we have a new statute this year that says that associations must not only post the fines, but actually send them out to the homeowners so that it's a very easy way for the owners to find out what they can be fined for and how much.
Instead of just being surprised when you get this and say, well, I had no idea I could be fined for that. Is that what you mean?
That's exactly right. And so my own personal hope is that will let the overreaching homeowners, overreaching associations stop doing what they're doing. So we've had examples. This one actually used to drive the legislators crazy when there would be a fine of $500 for a kid playing in the street. Oh. Now, I understand why they don't want kids playing in the street if it's a busy street, but why should you hit the parents up with another $500 fine? There's got to be a better way to do it. The parents don't want their kids to be hit by a car either. Right.
And so now they just have to be transparent, and you have to find this, and more often than not, so they have to send them to the homeowners, or would it work to just have them posted online?
I think it would work to have it posted online generally, but let me put it this way. If associations ask me, and occasionally they do, I say, send it to the homeowners.
Mm-hmm. For those things that you say we're entitled to, like budgeting or contracts, or, my HOA spent this amount of money for landscaping, how do I go about getting those? Are these open records requests?
Well, the simplest thing you should be able to do is just send a letter to your homeowners association. Mm-hmm. With most homeowner associations, that works. Those are, for this purpose, I'll call them the good homeowner associations. The ones that won't give you documents, I will call the bad homeowners associations. We do have a statute that provides a procedure that was intended to make it easier for homeowners to get their documents. And this is a place where you can use the justice courts or the JP courts. That statute hasn't worked out so well. Mm-hmm. And there are a couple problems with the statute. The first is, again, we're only talking about the bad homeowners associations. The ones that give you your documents, you never have to go to court.
We don't hear about those.
You don't hear about those. Right. But the bad associations, if they force you to go to court, you have three big problems. First, it's slow. Uh-huh. Second, if you use a lawyer, it can be hard to get your attorney fees back. And that's not because the judges won't do it, but because the homeowners association, after you've spent some money on a lawyer, will say, okay, we're going to give you these documents. Now drop your lawsuit. And you have a choice between saying, no, I want to go fight, and months later I'll get in front of a judge, mm-hmm. Or you take the documents and you've just lost your money for paying for the lawyer.
Because you had to get an attorney to compel them to basically see that you were serious about wanting these documents.
And often the homeowner association simply won't take an individual seriously in this context if they don't. Now, the last problem is that for the worst offenders, there are no sanctions. There is no way to hold directors accountable if they simply say, I won't give over the documents until the court tells me to. Mm-hmm. So they go to court. They've delayed things by 6 months or sometimes longer than that. In many cases, it causes all sorts of problems for the owners who want to organize or who get tired of waiting. Yeah. So we need a faster system. We need to be able to hold directors to account. That problem, by the way, is broader than just with the records. In a lot of areas, if the directors break the law, there's no consequence to them, and we'd like to change that. That's some of our proposals as well for this legislative session.
Well, yeah, I mean, we hear about laws with no teeth. It's basically, in essence, the same thing. There's this law, but if they don't abide by it, then, oh well. Which brings us to another question, actually, from another one of our viewers who actually asked, is there an entity that I can contact to report non-compliance to?
And the short answer is, you can contact anybody you want.
Is there
but
anybody who's
they're
going
unlikely
do
to do very much. So, for example, the Attorney General has authority over all nonprofits in the state. The Attorney General doesn't typically get involved in individual homeowners association disputes. In a small number of cases, we've seen circumstances where local district attorneys have paid attention. Usually, to make that happen, you have to have your own political connection. I'm sorry, but that's what it usually takes to get the association, to get the government to pay attention to a homeowners association problem. Most of the time, the elected officials would prefer not to get involved in fights between neighbors because it's very hard to know who's right. Go back to something I said in the first segment. If you have a group, if you go to the DA with 100 owners and say, we have a problem, then the DA is going to pay attention. But if it's, unfortunately, if it's just Amy or just me or just you, the DA is going to put you low on their priority list. And in the real world, we haven't seen very many DAs getting involved in these. Yes, it does happen, but it's very rare. So
we have a couple more questions from viewers that I want to ask when we come back, but also talk about some of these other things you're working on. That is just one of the ideas that you guys have to bring before the legislature, is some sort of consequence penalty for HOAs that are slow to or fail to comply with these laws.
Right.
All right, we'll be right back. Welcome back to this episode on homeowners associations and your rights. Our guest today, David Kahne. We've gone over a lot of things, documents you're entitled to. I have another question that I wanted to ask you, and this comes from a viewer named Nicole. She says she moved into a gated community that was, sold as a 55-plus community. So she planned on living out her days there. She says that none of the facilities or the amenities, like the pool and the gym, are ADA compliant, and she wants to know if this is required.
So all homeowner associations, like lots of other businesses, must comply with the Fair Housing Act and the Americans with Disabilities Act. And that does mean, for example, recreational facilities need to be accessible. The easiest way to see that is in a gym. Lots of us go to the gym. If you go to the gym, you'll often see someone who uses a wheelchair. People who use wheelchairs and with many other disabilities can use a gym just like everybody else. So gyms, if you have a gym in your homeowners association, it needs to have an accessible entrance, it needs to have paths, it needs to allow you to have equipment that you can use. The equipment usually isn't the issue, but getting in is often an issue. Pools are a more difficult question. If the pool has been built since the rules came into effect, yes, your pool needs to be accessible. If your subdivision is big enough, yes, your pool needs to be accessible. Smaller subdivisions may have an exception if it's too expensive to do the retrofit, but frankly, that's less and less of an issue these days because many of the pools have been retrofit, and when they're retrofit, then they need to be made accessible.
Got it. Okay. I appreciate you answering all these questions. When people have questions for me, a lot of times I'll direct them to you, but also a good place to go is the Texas HOA Reform Coalition. There's a place on that website where people can ask questions.
Yes, and it goes two ways. If you sign up to get the information from the HOA Reform Coalition, we will be letting you know what's happening at the legislature, and we'll be asking you for your experiences to help persuade the legislators to do the right thing.
And that's really where you get a lot of you're seeing sort of what people are complaining about, what issues they're having, and that helps you guys decide what laws you think need to be changed or adjusted.
Right.
So the next legislature in Texas convenes in 2025, January. You guys are already working on it. What kind of things are you looking at besides the consequences for non-compliance?
Right, we talked about consequences, we talked about access to information, we talked about giving condominium owners same protection as subdivision owners. Another really big one is, what do you do if the homeowner association makes a decision and it's wrong? Where do you appeal? Well, so for example, they tell you you can't build an addition on your house. Big issue for a person.
Yeah.
You've always been able to go to court. To go to county court or district court is very expensive, takes a long time. Especially for some of the smaller questions, we'd like to be able to let owners go to JP court, justice court, try to make it a much faster, much less expensive process. If the owner can say, hey, it says right here, I can do this. and the association says no, which does happen a lot, we're hoping that the justice of JPs will say to the association, let them do it.
Because right now, like you said, you can only really go to a JP court. They can only rule on yes, they owe you money, or they don't owe you money.
Or the documents.
Okay, all right.
All right, and then another issue that we're concerned about, and this is a big one, is how do you get rid of bad directors? Unfortunately, we have some directors that just seem to think this is what they get to do with their lives. They get to run the show forever. And owners often want to get rid of those directors. The process is called removal. And you can do it if you can win an election, but sometimes the elections don't go. So
by the rules.
By the rules, that's right. So we want to have a better process to be able to remove directors, a fast process to be able to remove directors. This gets back to something we talked about earlier. If you have a problem, what's critical is to be able to have a group. I'm trying to focus on helping groups of people because you can help more people all at once. It's very hard to help each individual person who is being told you have to cut your grass, you have to take down your artwork in your front yard. But if we can get groups of people to elect better directors or to remove the bad directors, that seems to me to be a priority, and I'd like to see the legislature recognize that and facilitate that for groups of owners.
Yeah, and how that can work out. That is a good one too. I think a question a lot of people have. You got any others?
Yes.
Okay.
So we often have directors who think that they get to amend the bylaws. And unfortunately, the law sometimes is that, yeah, they get to amend the bylaws.
Oh, those are their own bylaws that say they can amend the bylaws.
Their own bylaws, or they will just say we can amend the bylaws. And what we want to do is reverse it so that the owners are always the people who can amend the bylaws, that the directors only can amend the bylaws if it says that very clearly, and if that happens, we want the right for the owners always to be able to override that. And that will help in reining in directors who just think that they can stay there forever. We have problems with, similarly with, sometimes a group of owners will get one director elected out of 5. And that one director will be trying to do their job to protect and inform the whole community, and the other 4 directors will try to shut them down. And we've had all sorts of things, including one subdivision, or one condo actually, where the directors just voted the dissenting director off the island. They said, you're no longer going to be a director. That should be clearly forbidden.
But it's not, it wasn't in that case.
I would argue that it was, but
but they did it.
They did it. And what happened was that director, what she decided was, she said, I can't keep fighting this. And we want to have the laws support directors who are trying to do the right thing.
Yeah. I want to ask you one thing before we go. We talked to you about this whole perimeter fences. This has been a few legislative sessions ago where they said that anybody who wants a perimeter fence around for protection around their property was allowed, but then we were hoping in the next legislative session there might be some definitions of, you know, material, what you mean. Is this still an issue? Sort of what right do I have?
It's a huge issue. I call it security fences or security systems. And unfortunately, in the last session, it almost went the wrong way. The associations teamed up to try to persuade the legislature to take away certain rights to protect yourself. In that particular case, the governor protected the rights of owners and prevented that from happening. But I expect that we're going to continue to see that. Now, the right is not as broad as you describe it. The right is to have some kind of security fence. And what you mentioned earlier is absolutely correct. What would really help would be to clarify the extent of owner rights so that the associations know what they can regulate and what they cannot regulate. And the law does give the association some power to limit what you do, and there are endless disputes over who's right and who's wrong. All right, we could talk about this for 5 hours, but our producers won't let us. I appreciate you coming on today. We'll make sure we include links to the websites that we mentioned in the show notes. Thank you so much for joining us, and thanks so much for coming in.